The National Prosecuting Authority has issued a warrant of arrest for Gerhard Ackerman, who is accused of running a child sex ring. Ackerman failed to present a doctor's note on Friday after failing to appear in court on Thursday. He faces 740 charges, including child pornography, rape, and human trafficking. He was charged alongside senior advocate and acting judge Paul Kennedy, who committed suicide a few months after his arrest. Now, following Ackerman's no-show in court on Thursday, the NPA says it now appears that he has moved out of his home and sold all of his assets. He was granted bail of 6,000 rand in 2021 and had to report to the nearest police station daily.
The High Court of South Africa Gauteng Local Division in Johannesburg has issued a warrant of arrest for Gerhard Ackerman's arrest following his disappearance and an urgent application moved on behalf of the state. Ackerman failed to appear in court on Thursday, the 26th of January, for continuation of the trial against him for multiple counts of rape, human trafficking of minors for sexual exploitation, attempted murder, and distribution of child pornography. He is alleged to have participated in a sex ring targeting minor boys for sexual grooming and exposure to pornographic material, resulting in the minor boys being allegedly raped. We will use all available resources to apprehend Ackerman so that he can face the full might of the law. We have further embarked on an exercise that aims at promoting the safety of all victims and will welcome any assistance from the members of the public that can assist towards his apprehension.
So Ackerman is now on the run, and outrage is growing over how he was allowed bail in the first place with such serious charges over his head, and the fact that his co-accused, acting judge and advocate Paul Kennedy, committed suicide. Let's get the views of Luke Lamprecht, who's the head of Advocacy for Women and Men Against Child Abuse. Good evening, Luke, and welcome to the program. It's such an awful story. This is dubbed South Africa's biggest sex ring criminal case. The 740 charges are just a script of pure evil. We'd like your reaction, perhaps as an opener, on the fact that Ackerman has now vanished.
Good evening, Iman. We are absolutely outraged. We started with Mr. Ackerman actually in the case in the Alexandra court. We had lured a boy allegedly into a toilet and sexually assaulted him in a toilet on a sports ground. While he was standing trial for that case, he was arrested in the Kennedy case, and he was given bail while he had actually committed an offence while out on bail. Now, when we made the High Court aware of it, and we said to the High Court there are multiple other cases involving this man, they started centralising them. So it wasn't only the one in Alex, there were others. And he was still granted bail. There's no conceivable way in my mind that he should be eligible for parole. And there's no way he's going to give himself up easily to come back because he faces a very, very lengthy prison sentence.
And I should have done this perhaps at the beginning, Luke, is just to let our viewers know who are watching this interview that there might be some details they would find sensitive and upsetting. It is a really horrific case. I'm glad that you raised the issue around bail because, what happens in the court when issues like you've raised, while someone is on bail, one would imagine that there would be an immediate revocation of bail, or when the court is aware of just the litany of charges and that in fact this is a more serious case than perhaps was outlined in the very beginning. Do they change midstream their decisions, and how does that usually work?
So there's 2 points of consideration. The first point to consider is the fact that everybody's innocent until proven guilty, and as a result, bail is there in order to ensure your return to court to stand trial. So if there's a worry that you, for example, don't have a fixed abode, or you don't have money, or you have no sort of vested interest in staying around, they may revoke bail. But generally, offences, people get given bail because they're innocent until proven guilty, and bail isn't there to punish, but rather to return for trial. However, the second element is the important one. So the schedule of the crime determines a very important element of bail. So if you want to revoke bail when a person's on a lower schedule crime, the state has to oppose bail. But in Schedule 6 offences, like many of these are, the accused has to prove exceptional reasons for him to get bail. Now, in the instance of when he was out on bail for the first case and then reoffended, for me, there would be no question that while a person is out on bail and he allegedly reoffends, that he should never get bail in the second offence. So that brings us to the fact that there was a second accused in the case. He was a very influential legal and social person, and it is our belief that if it wasn't for his co-accused, Advocate Kennedy, Mr. Ackerman would not have secured bail.
In fact, let's just go to that directly. He was a renowned human rights lawyer and acting judge. We're talking about Advocate Paul Kennedy, the co-accused. And it's just bizarre to think, Luke, that while he was leading evidence at the State Capture Commission, he was being investigated for crimes including rape and the exploitation of small boys. Just, you know, for viewers who aren't aware of the role, the alleged role that he played, just shed some light on that.
So there's three levels to his involvement. So firstly, him and Mr. Ackerman would procure boys for the sexual use and sexual abuse and exploitation by Advocate Kennedy. They would also procure slightly older boys, so in other words, boys that are just over 18, 19, to then have sex with the younger boys while Kennedy watched allegedly and then participated. And in addition to that, they then recorded some of it in order to manufacture child pornography. So he's like a, for want of a better phrase, a co-conspirator, someone who worked together with Mr. Ackerman to procure the boys, abuse the boys, have the boys abused and record it.
Those details, as you're sharing, they are just horrific. And to add, they allegedly transported by bus and rail, kept in two houses, literally hand-delivered to Kennedy to do these acts that you've described. And then this led to the murder charge being added. But I want to go to you maybe explaining to our viewers how culpability is ascribed when you have more than one accused who played different roles in a crime like this.
Right. So in the trafficking exploitation legislation, if you procure a child, so in other words, you take a fee or you pay a fee, so you benefit from the transaction, there's an offence. If you advertise, because believe it or not, he actually advertised these children, so you are now engaging people to abuse the children for a profit. In addition to that, you are renting a place of abode, so somewhere where these children can be abused. You pay money for the rental and you're setting up a place where these children can be abused, where you are not detected, and then transporting the children to another home, which would say, for example, be Mr. Kennedy's home, and in addition to that, inviting other men to those places to abuse the children. So it's about the children being moved, used for sex, exploited, money being procured, property being secured, and transportation and facilitation and advertisement. So without the various players, the abuse couldn't occur.
Such a sophisticated setup, it would appear. Now, the charges against him have been dropped. This is Kennedy, and the indictment has been amended. But Ackerman could face the music for his crimes because of this doctrine of common purpose. How would that work in practice?
Okay. So the common purpose is you're working together for the same cause. So while Mr. Ackerman may not have, we don't know yet, but while Mr. Ackerman may not have participated in sex with the boys, without him advertising, transporting, paying, facilitating, giving a place of residence, and giving the offenders who are coming to abuse the child a place of residence, the offence could not have occurred. So in other words, the common purpose is Mr. Ackerman, even if he didn't actually abuse the children, in other words, he wasn't involved in the physical abuse of the children or the sexual abuse, without him, Mr. Kennedy and the other men that have not yet been named could not have committed it. So it's, for example, you rob a bank, you that getaway driver in the car, you're not the one in the bank who's robbing the bank, you're still guilty of robbing a bank. If someone gets shot, you're still guilty of murder, even though you're sitting in the car outside, because you are the getaway car. So you're working together to ensure a crime is committed, and you commit different parts of the crime, but you're charged with the same crime.
So Ackerman has said that he's pleaded not guilty to all the charges, and he said he was not going to testify. We understand these victims will be heard in camera. And just a mention on those victims, wounded, bruised, broken, already having come from exploitative or backgrounds where they were exploited into a further just awful exploitation that the court is hearing. How does the court, in this context, go about effectively and sensitively getting the information and evidence that is needed from them to convict?
Yeah, so there's three levels. The first complication is the fact that there are what people colloquially in the law calls images of child pornography. We are quite adamant that they should be called images of the sexual abuse of children because that's what they are, they're crime scenes. So the showing of that evidence can obviously not be done publicly. It cannot be done in an open court. It cannot be done where there are people like interpreters and bailiffs and orderlies and that kind of thing present, because they are, number one, severely traumatizing, number two, severely degrading to those in the images. So that's generally held in chambers or completely in camera, so they empty the court or it's just done in the judge's chamber. In terms of the child witnesses, the children should sit in a separate room. They are given a person with a particular qualification in child development, say social worker or teacher. That person has a set of earphones. The questions are asked to that person. They are mic'd. The child is mic'd. And the child and the intermediary are seen in the court. So in other words, we hear the questions, we ask them developmentally appropriately to the child answers, the court sees it. If the children have become adults in the process of the trial, which I think might be the case for some of the victims here, then you have the opportunity of the child being in a separate room, but without the assistance of a child development person. So in other words, they've got the headphones, they hear the court, but they're not in court to see the accused. And finally, all of that is held in what's called in camera. In other words, nobody other than a support person for the child, so like a parent or a therapist or a person like that, and then the parties directly involved in the legalities are allowed in. So in other words, we have an open justice system, so it's public justice, and in these cases, the media and the public are asked to leave while that evidence is there.
Luke, we'll leave it there. And thank you for sharing that detail and just enlightening us on some of the complexities of how you go about hearing evidence from victims such as these in this really awful case.